Okay, hello everybody. Welcome to our second instalment of the 2022 University of Bradford and Proctor and Hobbs mock trial competition. You will introduce yourselves when we get started. So just to take, just so that we get all the paperwork in order. Today's topic again, a criminal law matter, which concerns the potential Section 47 of the Offence Against the Person Act offence, where a YouTube prankster, appropriately enough, for we are being broadcast live on YouTube, I'm being reliably informed, has injured somebody during the course of a YouTube prank. I will allow our prosecution to introduce the facts of the case when we get started. But yeah, good luck to everybody. When you stand up, just make sure that you give your full name for the record and what have you, and we can get going. I think we're all in order. Yes, I'll be swearing everybody in. There'll be no clerk. So hopefully everything will go smoothly and quickly. And I will invite our prosecution to introduce the case. Thank you.
Thank you, Your Honour. Good afternoon, ladies and gentlemen of the jury and members of the courtroom. My name is Tyler Parkinson, and I will be the prosecutor in this case. On the date of the 25th of August of the year 2021, the defendant approached multiple citizens at a popular smoking shelter in Bradford. He was concealing a water gun with which he intended to spray citizens as they were lighting cigarettes. On this most unfortunate instance, he approached the complainant, Miss Sarah Banks, who was and her colleague, Miss Sally Hussain. Unfortunately, Miss Banks was startled by the presence of the water gun and attempted to flee the scene so as to avoid the powerful jet of water that was heading in her direction. As a result, she collided with the side of the smoking shelter, rendering her unconscious. As a consequence, she suffered a broken nose and a concussion of which the effects lasted for 2 months. Therefore, we have charged Mr. Savage, the defendant in this case, with assault occasioning bodily harm, contrary to Section 47 of the Offences Against the Person Act of the year 1861. Ladies and gentlemen of the courtroom, this case concerns a defendant who acted recklessly in pursuit of a prank, and a young and innocent victim who suffered severe bodily harm as a result of this careless behaviour. Of course, the defence during this trial will try to argue that the presence of a water gun is not severe enough to cause any such harm. They'll also try to argue that the harm was not reasonably foreseeable. However, nevertheless, we will call upon a complainant and a witness in this case so as to testify to the injuries and to the events which led up to them. During the course of the trial, the prosecution will call the complainant and one witness. We'll call Miss Sarah Banks, who will testify that she suffered severe bodily harm as a result of the defendant's actions, and we'll call Miss Sally Hussain, who will testify of the defendant's guilt and of the actions he committed. At the conclusion of this case, we would ask you to review the evidence and determine ultimately that the defendant is guilty of causing severe bodily harm. Thank you.
I shall just swear in our defendant before we get started properly. Do we have a Mr. Timo Savage in the court? Hello. Good. If you could just stand there. Stand up, please, if you could. Thank you. Just for the court's record, please, could you just confirm your name and address?
Timo Savage, 77 Ashbourne Way.
Okay, thank you very much. And if you could repeat these words after me, please. I do solemnly, sincerely and truly declare, and affirm, that the evidence I shall give, shall be the truth, the whole truth, and nothing but the truth. Thank you very much. You may sit down. Would you like to call your first witness?
Yes, if it please the court, we would like to call Miss Sarah Banks to the stand.
Thank you, Miss Sarah Banks. If you could take the witness stand. Thank you very much. If you could remain standing for a second, and I'll swear you in. Yes, just confirm your name and an address for the court, please.
Sarah Banks of Waverley Place 19, BD8 5'2".
Thank you very much. Okay, and if you could just repeat after me. I do solemnly,
I do solemnly,
sincerely and truly declare
sincerely and truly declare
and affirm
and affirm
that the evidence I shall give
that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Tremendous. Thank you very much. You may sit down.
Thank you.
Your witness, please. Mr.
Miss Banks, how are you feeling today?
Bit nervous.
Bit nervous. There's no need to feel nervous around here, but I understand. Could you please explain your connection to this case for the benefit of the court?
Yeah, so on the 25th of August, I was just out having a cigarette break with Roy, that's my colleague, and then all of a sudden I saw some water spraying myself all of a sudden I just saw a splash of water. I've run the opposite direction and I don't really remember much, but I banged my head into the shelter pole and then that's about it, and then I can't really remember after that.
Thank you, Ms. Banks, for your explanation of the events. So how did you feel in this instance when you saw the jet of water heading your direction?
To be truthful, I was quite scared. So about 5 years ago, I had this. I still have this friend. Me and her. She had a very controlling boyfriend. I can't begin. I don't even know where to start. He wouldn't let her leave her house or, go to possibly grocery shopping, anything without him with her. So she just had to, listen to him and kind of be closed up. I do remember the day that she finally told me she was breaking up with him. We thought, let's go celebrate, have a drink, party. So we went out to the club. We usually go to the club called Light, I think. So we went there, we had some fun, and then I just remember a shadow, a tall, dark male shadow, and just some spray, and it directly went into her eye, and then we later realised it was acid, and then she had severe acid burns on, and we realised it was her ex-boyfriend who possibly was jealous, hated the fact that she was out even without him and that she broke up with him. So after that, honestly, any liquid or any form of liquid, it just terrifies me.
Thank you, Miss Banks. That was a very brave story to share. So in this instance, would you say that you were made to fear for your immediate safety?
Yes, 100%.
Okay. Were you able to get a view of the assailant?
Yeah.
And could you identify them for us, please?
Yeah, it's that man's sitting right there.
Okay, and let the record show that she's making reference to Mr. Timo Savage, who is the defendant in this case. Okay, in your witness statement it says that you suffer from anxiety. Is this correct?
Yes, that's true.
And how long have you suffered from it?
It's been 5 years and I still suffer now.
And your decision in this case to flee the scene, it was triggered by your anxiety, correct?
Yeah.
Has your mental well-being suffered any harm as a result of this event and because of the defendant's actions?
It's just made it worse, to be honest.
It's made it worse.
Yeah, just being in that hospital for 2 weeks, and I even broke my nose. It's horrific, and I just thought, imagine I had brain damage or something. It scares me of the thoughts and the ifs. Of
It is a
what would
horrific
happen.
circumstance for any of us to go through, and you're very brave for sharing it. So, you did suffer physical injuries from this,
Yeah.
and could you please state the nature of these injuries?
Yeah, so I broke my nose, and I just remember having, a concussion for about 2 months, I think roughly 2 months. I just felt dizzy, tired all the time, and it was just painful, the experience.
Do you think that Mr. Savage ought to have been aware that there could be potentially repercussions to this prank? Do you think?
Oh, 100%. If you're out there spraying, someone with water, and sorry.
We're calling for speculation as to the views of the defendant.
Okay.
That's how I understood the question.
Okay, yeah,
Yeah,
that's...
if we could move on from that.
Okay, thank you, Ryan. So how have these injuries affected your work?
It's not been good because I'm quite insecure. I'm not really comfortable with my teeth. I'm already uncomfortable with certain body parts. And then for the fact that I broke my nose, it's just not. It never sits right as it used to before, and it's just quite. When going work, I feel really nervous and scared, and just what will people think of me? So it's affected me emotionally as well as physically.
And because of the injuries, you were forced to take time off work, correct?
Oh yeah.
So finally, do you agree that the injuries wouldn't have happened if it wasn't for the defendant's actions?
Yes, I do.
So that's to say that because without the defendant's actions, you would never have got injured in the first place.
If he didn't spray at all, I wouldn't have ran in the opposite direction and hurt myself.
Thank you, Ms. Banks, for your brave testimony. I have no further questions at this time, Your Honour.
Okay, thank you. Good afternoon. My name is Hussein Al-Kachkach, and with the permission of the court, I would like to cross-examine the complainant.
Yes, please.
So, good afternoon, Ms. Banks. How are you today? Good. Do you recall what happened on the 25th of August, 2021?
Yeah.
Can you identify that the person in question is in court today?
Yes, he is.
Additionally, could you describe the operations of your day when the incident had occurred?
I was just on a lunch break with my colleague, and usually around this time we go out for a quick cigarette break.
Okay. And would you consider the smoking shelter you were at to be a public place or a designated area for employees?
Most likely a public place, but all our employees do go there.
Okay. So, following from that, are you generally aware of recklessness within a crime?
I'm not sure. I don't understand your question, sorry.
Okay, so are you aware that the actions of someone may contribute towards a crime?
Yeah.
Okay. And wouldn't you say that the actions of an individual may differ within crimes?
Yes, possibly.
Okay. So I've asked this because I wanted to distinguish recklessness within a crime and the case which is upon us today. So according to your witness statement, you had mentioned that you were a witness of an acid attack occurring with your friend. Is that correct?
That's correct.
So can you explain further what happened on the night and particularly what your role and what you were doing on the day?
Yeah, so essentially we just went out to have a bit of fun, party. Just making sure, is this about the acid attack?
Yes, it is.
Yeah. So I was with my friend. We were really, happy that she's basically let loose of that controlling ex-boyfriend. We were just having fun. And then all of a sudden I saw a very dark figure coming out, and then there was a few sprays of water directly into her eyes, and as soon as I saw it burning her, it was just horrible.
Okay,
Yeah.
and you would consider a nightclub to be a public place as well, is that
Yeah.
correct? Okay, thank you. So prior to the incident on the 25th of August with the defendant, Mr. Savage, had you had a similar occasion where you felt anxious or nervous at all? Even except for the incident at the nightclub as well?
I can't recall, but yeah, I can't recall, no.
Okay. In relation to the incident that had occurred, you said you saw a jet of water coming towards us.
Yeah.
Who else was with you at the time this had occurred?
My colleague Roy.
Okay. And did the water in fact touch you once you saw it coming your way?
To be quite frank, all I remember is running the opposite direction, and then I blacked out. I can't remember anything after.
And you also mentioned previously that you did see Mr. Savage on the day of the incident.
Yeah.
Okay. Do you think the actions of Mr. Savage were reckless at all?
Yes.
And do you consider the actions to be intentional to cause you harm in any way possible?
Well, I won't know. I'm not him.
This is
Okay.
for the jury to determine.
Okay. My
So-
apologies, Your Honour.
If we could leave it to them.
You also mentioned in your witness statement that you see liquid spraying everywhere.
Yeah.
Is this correct?
Yeah.
Okay. You've also stated that you suffer from severe panic attacks and anxiety. This is also correct?
Yeah, that's correct.
Okay. And if I may ask, do you seek any medical or professional help as a result of the trauma that had occurred?
I have my friends and family. I think I did contact my GP, but it was closer to the time of the acid attack. Can't really remember.
Okay. And would you also state what the weather conditions on the day were?
I think it was just sunny, dry. Can't
Okay.
remember.
So, just as a matter of just wanted to inquire, would you say that a view of a person would be slightly impaired due to vibrant sunny conditions, and one may struggle to see?
If we were possibly in Thailand with the sun blazing, maybe, possibly, yeah.
Okay. And lastly, by smoking in a public area, do you see any foreseeable risk to yourself, especially if members of the public are around?
No.
Okay. Thank you, Your Honour. That would be the end of my cross-examination. Do you have any questions?
None for you, no. There may be some in re-examination.
I only have one question
Yes.
to re-examine. In his last question, the defence mentioned how you wouldn't see any foreseeable risk to yourself in a normal circumstance when you're at a smoking shelter, correct? But in this instance, this wasn't a normal circumstance, was it?
No.
Somebody approached you with a water gun
Yeah.
that caused you to fear for your immediate safety.
Yeah.
So you could see foreseeable risk in this circumstance.
Yes.
Thank you.
In this circumstance, yeah.
That's it, Your Honour.
Okay. Thank you. I have nothing more. You may sit down. Thank you. Okay. Would you like to call your second witness?
Yes, we would like to call Miss Sally Hussain, please.
Thank you. Sorry, so... sorry, yeah, if you could just remain standing, I'll swear you in. If you just confirm your name, please. Okay, and address, please.
It is not on this statement. It's not on here. So I'm not sure what the address is. I don't have it on the paper.
Okay, we'll establish that in due course. And if you could just repeat the oath, please. I do solemnly, sincerely, and truly declare.
I do solemnly, sincerely, and truly declare
And affirm.
and affirm
That the evidence I shall give.
that the evidence I shall give
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
Thank you very much. You may sit down and await questions.
Mr. Hussain, how are you feeling today?
I'm okay.
Good. What connection do you have with our victim?
I was just a friend
She's a friend and a colleague, correct?
and colleague, yeah.
How would you describe Miss Banks as a colleague and as a friend?
A good colleague to be working with, and we've known each other for quite a while.
Okay, so according to your statement, you were with Miss Banks at the time of the attack, correct?
That's right, yep.
Could you please describe this event as you remember it?
Yep. So as I came out from work, I needed a smoke break, and from what I can remember, everything happened quite quickly. So my memory's rather vague. Nevertheless, I was stood turned away, and when I did turn around, I saw my friend hit her head off of a pole and fall to the floor. I soon rushed over to call an ambulance. Within a few minutes, the ambulance had arrived, but my friend and my colleague were still unconscious. I then later learned that the water that was coming was from water from a water gun.
Okay, were
And
you
that's
able to
the-
get... Oh, sorry. No.
Sure, and that's all I can remember from the event.
Okay, thank you. Were you able to get a view of the assailant?
I'd say so, yeah.
Okay, could you please identify them for us?
From what I can remember, I can't clearly remember. No.
Okay, that's okay, Mr. Hussain. It says that here that it was you that called for medical attention, correct?
Mhm, yep.
Very selfless act, Mr. Hussain. And Miss Banks, she was still unconscious when medical attention arrived, correct?
That's right. Yep.
At any point after this incident, after she collided with the shelter, did you fear that the injuries could be worse than a concussion or a broken nose?
It didn't occur to me. No.
Would you describe Miss Banks' injuries as being severe?
I think so. Yeah, because even weeks on now, I've heard that she's still being affected and she's still not fully recovered.
Okay, and do you agree with us and Miss Banks that the actions, the consequences could not have occurred without the defendant's interference?
I do believe that.
Would you say that the defendant acted recklessly?
I'd say so. Yeah.
So in other words, you think he ought to have been aware of any potential repercussions?
Should have been.
Okay.
Important perspective as to the frame of mind of the defendant. These questions are much more appropriate to be put to the defendant,
Okay.
and for the jury to make their determination on that basis.
Okay, my apologies, Robert.
No, you're fine. Carry on.
At any point did you fear for your own personal safety, Mr. Assailant?
No, I didn't.
I'm glad to hear that. And as a result, did you suffer any psychiatric injuries?
No, I didn't.
Okay, good for that. And to your best knowledge, has Miss Banks had any issues at the workplace?
So a few weeks on, I think it's still sort of affecting her to a certain extent.
Mm-hmm.
She's tried to return to some sort of normality. However, nevertheless, something like that would still stick with you.
Okay. Thank you, Mr. Assailant. Your Honour, I have no further questions for the witness.
Thank you. Defence. Cross-examination.
With permission of the court, I would like to cross-examine the witness. Is it correct that you were having a puff of cigarette at the time?
That's right. Yep.
Okay. Could you describe the operations of your day on the day in question?
So I was at work. It was a normal time at work. Nothing different. And then when I left work, just for a quick breather, this is when this event took place.
Okay. Have you by any chance watched YouTube videos before containing pranks?
I have, yeah.
Okay. And what do you think of them?
They're entertaining.
They're entertaining? Okay. So then I'm sure you're accustomed to the nature of them by which they may possibly entail. So could you describe the weather conditions under there as well? Again, please.
I can't clearly remember.
Okay. You state in your statement to the police you saw something flying towards you. Did you see what that was?
Yeah, but because it was too quick, I can't remember what it was, but something was flying towards me.
Okay. Do you know who this had come from?
Nope.
No. Okay. You also state that Sarah had hit her head. Do you know how this happened?
From what I believe, it was on a pole.
On a pole. Okay. Could it be fair to assume that her view was obstructed in any way possible?
I'm not sure.
Okay. And you did say also that it all happened very quickly.
Certainly, yeah.
Correct. Just to clarify, Mr. Hussain, did you dodge the jet of water that was approaching you?
I think so.
Okay. And that would indicate that mostly your colleague, Miss Sarah Banks, was not proximal, but rather distal to the jet of water. Is that correct?
I think so, yeah.
Okay. On many occasions, a deviant individual or criminal may flee a scene of a crime if they had committed and they may have felt guilty. Is this correct to say?
Yep.
Thank you. So can you explain what Mr. Savage did once Miss Sarah Banks hit her head?
I think he made off.
Okay. If there's a contradiction in the... Your Honour, sorry? If there's a contradiction in the witness statement, should I state that?
Yeah. Put the matter.
Okay. You did say that he did come towards you and help and waited for the paramedics to come.
Right.
Yeah.
Right. Okay.
Okay. Did he apologise at all in any way?
I can't remember.
Okay. Just to state, according to your witness statement,
Mm-hmm.
he did apologise and did wait for the paramedics to come. And would you also say that he was fully cooperative at the time when the incident had happened?
Yes, yeah, so actually when I do look back at it now, once the paramedics were called, he stayed there for a few minutes and then he did apologise.
Okay, thank you. And would you say that the defendant acted recklessly in any way based on what you saw at the time?
I wouldn't be able to determine that in my capacity.
Okay. And also as well, did you would you say that the incident that had took place was merely an accident, or was it intentional?
Once again, I wouldn't really be able to comment on that.
Okay, thank you. That would be the end of my cross-examination, Your Honour. Do you have any questions?
I do feel I'm not seeing the where in the witness statements of Mr. Solomon Hussain that there isn't reference to Timo having apologised. I can't see that. Can you point it to me?
I believe that was in Timo's statement.
Timo's
sorry.
own
Yeah,
statement.
my
Okay.
apologies.
I see.
Yeah,
In that
my
case.
apologies, Your Honour.
Okay, yeah. Yeah, I was a little confused. Okay, thank
Okay,
you.
thank
yeah,
you.
in re-examination.
No, Your Honour, I have no re-examination.
Okay. Can I just clarify one point, however? It was raised about the proximate distance to the water with regards to where Sarah was and where you were and what have you. I'm not sure we entirely got a clear answer in that regard. You were asked if you were proximate to the water. Can we establish a bit more clearly? Yes. if that's
So would you say you were in front of her, or were you more close to the jet of the water at the time when it was fired?
So
Because as you had my apologies, as you had initially dodged, that would indicate that you made the first course of action.
I think I was pretty much in front of her.
Okay.
Mhm.
All right. Thank you, Your Honour.
Okay, right. Thank you. You may sit down. Or return to your seat. Okay, we turn to defence witnesses.
Your Honour, if I may provide a brief opening statement.
Yep. Well, okay, briefly.
Okay. Your Honour, members of the jury, my name is Assailant, and I appear under defendant Mr. Timo Savage. Today I will be challenging the prosecution on element of mens rea of a section 47 assault to a person. You may hear from the testimonies of the witness that the incident on the 25th of August 2021 was merely an accident, as well as there being no intention to cause harm to the complainant. If it pleases the court, may I please call the defendant, Ms. Timo Savage, to the stand?
Of course. Thank you. Thank you. We have your name and address, and we have sworn you in. You remain sworn in. I believe we took your plea, which is one of not guilty, but we'll just clarify that for the record. And yes, you may sit down and await questions initially from your defence barrister. Thank you.
Good afternoon, Mr. Savage. How are you today?
Doing very good. What about yourself?
Very good, thank you. What were you doing on the 25th of August 2021?
On the 25th of August, I went into Bradford, into the city centre. There was a big area where I usually do pranks, and I filmed another prank there. I set up 3 cameras on the day near a shelter that I usually go to as well, and I believe it's called the Smoking Gun. It's a very popular place where people go to smoke, and my intention there was to film a prank video in that particular area. And there was people walking by, and what my intention was to shoot people with a water gun when people had cigarettes in their hands. That's what I did on the day.
Okay, thank you. And would you consider this creation of content to be a profession or a hobby of yours?
I would say that's a very good question. I believe it's a hobby because I like doing it. Although when you
Okay.
consider YouTube, it could be considered a profession, but I would say it's more a hobby.
Okay, and you also did state in your statement to the police, or in your witness statement as well, that you intended to get a lucrative salary from that creation of the video. Is
That's
that
right,
correct?
yes.
Thank you. On the 25th of August 2021, there was an incident involving yourself and Miss Banks, from which there is now a trial. Could you explain to the court what exactly happened on the day?
So for the trial, I guess, there was a few people I was aiming my gun at, and one of them happened to be the complainant, Miss Banks. And in fact, I was not aiming the gun at her at all. I believe there was a person in front of her. And when I shot the novelty gun, the water gun, it happened to miss the person I was aiming at. And then the person behind the person I was aiming at, she happened to be very scared. It appeared that she was scared. And she turned back, exclaimed, and ran into a pole, I believe. That's what happened with my incident of shooting the gun and Miss Sarah Banks, from what I recall.
Okay, thank you. And with all that said, was there anyone else with her at the time that you could
believe
fully
so.
identify?
I believe so, yes.
And is that person in court today?
He was, yes.
You mentioned in your statement to the police you had missed a shot, is that correct?
Yes.
Yes. And did you intend to spray Miss Banks, or was this directed at someone else?
Could you repeat the question?
Did you intend to spray the water gun at Miss Banks, or was this directed at someone else?
He was directed at someone else, yes.
Okay, thank you. In many cases, a person would flee. Can you explain to the court what you did once Sarah injured herself?
Yeah. So even just before that, I didn't realize that someone got hit. But when I noticed that Miss Sarah Banks was hit, she had hit herself into the pole. I ran over very, very quickly, along with many other people. And immediately we noticed that she needed medical attention. So I stayed there. Because if there was no need for medical attention, I would have just gone back to my place. But because there was a necessity for medical attention, I stayed just to make sure I explained my side if I was needed. And that's what I did when I seen Miss Banks fall over.
Okay, thank you, Mr. Savage. Prior to the incident, could you explain the altercation that you had with another member of the public?
Yes. Oh, okay. I do recall the other person. So on the day, I imagine I shot quite a few people smoking cigarettes. I would not shoot someone who didn't smoke a cigarette. And there was one person who was very chirpy, and I shot him with the same novelty water gun. And with him, I approached him after I hit him. He seemed a little bit annoyed, but at the same time, luckily, he's seen the fun side of it, as I seen the fun side as well. And with him, I spoke to him very briefly. I paid him £20 for the little inconvenience. He was okay with it. And I think that was the end of our altercation.
Okay. Furthermore, can you explain why you compensate people after a prank?
Yeah. So I feel like I watch other people do this particular prank, and I just follow what they do. They pay people to kind of save them from the inconvenience, and just kind of allow people to get on about with it. If I don't compensate them, they would stay annoyed. But with the compensation, it's possible that they would allow it.
Okay. And would you say the compensation towards the person involved in the prank is fair and justifiable?
I think so. Yes.
Okay. Thank you, Your Honour. That would actually my apologies. Additionally, according to your witness statement, you had mentioned that the water gun was purchased from a children's toy store. Is that correct?
That is correct, yes.
Okay. Is there a particular reason why you chose to buy the gun from the toy store?
Well, there are quite a few different types of novelty guns, as they say. I felt like it would be a lot safer if I used one, to be fair, particularly powerful one, but within the context of a toy shop, it would be safer. That's why I chose that particular shop.
And based on what you've just said, did you intend to cause anyone harm based on the type of instrument, or in this case, the water gun you had purchased?
Well, absolutely not, no.
Okay. Thank you, Your Honour. That would be the end of my chief examination. Do you have any questions?
Not just yet. Thank you. Cross-examination, please. Thank you.
Mr. Savage, how are you doing today? Not bad, thank you. In your statement, it says you are unaware why you could be considered having committed any criminal activities. That's correct?
That is still correct, yes.
Do you understand the charges that have been brought against you?
To a brief extent, yes.
Okay, you understand that you've been charged with assault occasioning bodily harm. Do you know what this means?
Occasioning bodily harm, no, but I'm aware that it's assault, but I don't know the second part of the crime.
Okay. Of course, you did not actually hit our victim physically.
No.
But do you understand that an act of assault does not necessarily need any physical contact whatsoever?
I did not know that, no.
Did your attorney not explain this to you?
No.
Okay, Mr. Savage, allow me to inform you that assault is merely caused by inflicting fear or aggravating another individual. For example, if I was to raise my fist threateningly at you, then I could be considered liable for assault regardless of the fact that I haven't actually made a move. Do you understand this now?
That particular thing you mentioned does make sense. I'm still unsure why that's why you'd mention that to me for this trial, but it does make sense though.
Okay. Now that you understand, do you see how the posing of a water gun could be considered as aggravating or threatening?
No, not really. It's a toy gun. It's a novelty gun, you see. No. So to me, no, I don't think it would be fearful.
So you never expected that somebody might be annoyed as well. I did mention it could be aggravating, potentially.
Annoyance for sure. I don't know about aggravation, that's quite strong, but for sure, even people were definitely annoyed. Though I do provide compensation to get rid of the annoyance.
Okay, so did you not anticipate that somebody may try to run away from the spray of water from the water gun? May try to avoid it?
On the day, no, but I guess in the back of my mind, I would imagine some people would try to run away, yes.
Okay, did you ever consider that there could be repercussions from the prank?
Well, from the prank itself, yes, but by me doing it, no, because I've been doing it for a long time and there's never been any repercussions. So because of that, I would say no. I did not predict to be any repercussions.
Okay, did you notice how enclosed the shelter was?
I can't really recall, but if you describe it to me, I can agree or disagree with you. I can't recall myself.
Okay, it's a popular smoking shelter, so obviously it has some sort of width to allow multiple people in it at the same time. But did you consider how, walls, there's a roof on top of it? Did you not see how if somebody tried to run away, they could run into it?
It depends. That's fair. I feel like it depends on the distance the person is from the shelter. It seems like a fairly medium-sized place. If you are pretty close to it, then potentially they can run into it.
Okay, in hindsight, would you say that it was reckless to ignore this injury? The
Absolutely
potential
not.
for injury?
No, I still don't think it's reckless at all.
Okay. It is true that you were offering a £20 compensation prize for everybody who was a victim of your prank, correct?
Correct.
And why was this?
Again, because I noticed from the videos I watched previously, the people who were pranked, they would be annoyed, and when money was provided to them, they seemed to be a little bit happier, so I thought I'd do the same thing, and it worked.
Did you ever think that the compensatory prize might not be enough to deflect their annoyance?
I guess everyone has a different price, isn't it? But for the people I did pay, everyone was happy with £20. But I'd imagine if people weren't happy with 20, I could negotiate. But 20, everybody was happy with.
Okay. Do you feel any remorse for the actions, for everything that's happened since?
Yeah, absolutely. I guess for Miss Sarah Banks and the injuries she sustained, that's absolutely beyond my control, and I feel very, very bad for that. I didn't even notice that would happen, but because I've seen it, if I was in a position, I would not be happy. So absolutely not.
Okay, Mr. Savage, thank you. I have no further questions for the defendant, Your Honour.
Okay, thank you. Anything in re-examination?
Commissioner of the Court, may I re-examine?
Yes, please.
So you've mentioned that this has never happened before. Do you believe that the incident was foreseeable? And
The incident, no. The injury, I believe
Yeah.
that was not foreseeable. No.
okay, thank you, Your Honour. That'll be all.
Okay. Right, thank you. Just one thing, Mr. Savage. You referred to your gun as a novelty gun repeatedly. Can you just sort of explain what you mean by that?
So toy water gun, so there's like a spectrum when it comes to toy guns, and I feel like water gun is like the least dangerous type from a toy store. That's why I describe it as novelty, unless I've got the definition
As
wrong.
opposed to what, fatal
Well,
water guns?
yes, it's
or-
the complete inverse. To me, it's complete inverse to a fatal type of weapon,
Oh, I see.
So water gun,
You're
yes.
comparing it to actual
or even
guns.
or even general
projectiles.
guns like toy BB guns, stuff like that.
Okay.
Yeah.
All right. So in that sense, it's a novelty.
Yeah,
So
in
it's
my
not
view.
a novelty in the range of water guns.
Ooh,
It
within
is,
the range.
it is a powerful gun, is it not?
Yes, it would be a powerful gun. Yes.
Okay. Okay.
As
thank
far
you.
as water guns go, it's a powerful water gun. Yeah.
Right. Okay. Thank you. You may return to your seat. Thank you. And your final witness, please. Yeah.
Or I may call Christian Ahab to the stand.
Thank you. If you could just confirm your name and address, please.
Christian Hobbs, Cotton House, Great Cotton Road, Bradford.
Lovely, thank you. And if you could repeat the oath after me. I do solemnly, sincerely,
I do solemnly, sincerely,
and truly declare
and truly declare
and affirm
and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. You may sit down.
Thank you.
Thank you. Good afternoon.
Good afternoon.
Can you explain the operations of your day on the 25th of August 2021?
Okay, thank you. On the 25th of August 2021, I'm a bus driver, but on that day I was off and I decided to go into town in Bradford. That's the Broadway shopping mall to get a few items. And when I was done, I just felt okay. Instead of going back home, I decided to stop for a smoke. And I was outside. And as I was about to lighting my cigarette, I noticed water on my face. And looking up, I discovered that it was Mr. Timo, who I would later a man who I would later find out to know was Timo, trying to play some pranks for his YouTube channel.
Okay. Can you inform the court as to what happened with yourself and Mr. Savage on the day?
Okay, so on the day, like I earlier mentioned, I stopped for a smoke, and after the incident happened, when he shot the water gun at me, I was a little wet but not harmed, and he came, apologized, and handed
Okay.
me a £20 note.
Okay, thank you. As you've mentioned in your witness statement, you were slightly annoyed with the prank, but then later found this funny. Is this correct?
Yes.
Can you explain why you found this later amusing?
Yeah, because I love YouTube, and I enjoy watching pranks.
Yeah.
So I saw it as me being in a situation of those who I watch. So eventually I found it interesting,
Okay,
though annoying initially.
Thank you. Following from this prank, can you explain what Mr. Savage then did after he performed the prank?
Okay, he gave me £20.
Okay. And would you say this outcome was satisfactory enough to compensate for the water that he'd sprayed on you?
Yes,
whilst-
it was. It was. I
Okay.
could get extra burger with that and pizza.
May I ask, Mr. Hobb, did you see the incident that had occurred between Mr. Savage and later, as you would know, Miss Banks on the day?
Oh yes, I was still there. So on the day, what happened was that after he played the prank with me, I made him promise not to do that to me again, because obviously I was wet and it was a little cold. So I was like, so he promised not to do that. And then while we were still there, he shot the gun again at the lady I would eventually know to be Miss Banks, and she appeared a little scared. She was a little nervous and scared, and when that happened and Mr. Timo noticed, he actually came over and we all tried to calm her down and call the paramedics to help her. But she wasn't physically injured at the time, but she was nervous and a little apprehensive.
Okay, thank you. And after the altercation you had with Mr. Savage, do you think that he intended to hurt Miss Banks in any way possible?
No. He was just doing it for the fun of it.
Okay.
He didn't intend to hurt her. She was just scared. She just received it differently.
Okay. So would you agree it was an accident at all?
Well, accident that she was she became apprehensive. Yeah, it was.
Okay.
Okay, I allow the questionnaire and the answer to be heard. But yeah, if we could just avoid speculating as to,
Okay.
as to the state of mind of the defendant.
My apologies.
So if we could move on from that line of questioning. Thank you.
Okay, no more questions, Your Honour. That would be the end of my chief examination.
Thank you.
With the permission of the court, I would like to re-examine this witness.
Yes, please.
Okay. Miss Ahab, you were the first victim of the defendant's prank, correct?
At the time I was there, yes, that I witnessed.
Okay, so just to confirm, you didn't have any connection with either the victim or the defendant prior to this?
No. That was
You-
my first time of seeing both of them.
Okay, so this was your first interaction with both parties. According to your statement, the defendant offered you a £20 compensatory prize for the prank, is this correct?
Yes.
And why would you say that he offered you this prize?
Well, I think he offered me the price for the inconvenience.
Mhm.
Obviously, it wasn't so cold, but I was wet. So I guess he just gave me the money to, for the discomfort that the prank had cost me.
And
Not
prior...
necessarily to bribe
Sorry.
me, as it were.
My apologies. So, and prior to him coming back and giving you this £20, you felt annoyed with the defendant, correct?
Yes, a little angry
So,
because it was unexpected and I was wet.
so would you say your forgiveness was dependent on the compensation?
Firstly, he explained why he was doing that. He explained that it was for his YouTube channel. And then obviously that pacified me because, like I mentioned earlier, I watch a lot of pranks on YouTube myself. And then the £20 went the extra mile, but that was not the premise upon which my forgiveness was based.
So you would have forgiven him regardless of the price?
Yes, I would still have.
Okay, thank you. In your report, you described Mr. Savage as being sheepish when he came back to apologise.
I described?
You described Mr. Savage as being sheepish, timid, so to speak.
I didn't use sheepish. I said she was apprehensive. She
Apprehensive.
was scared.
In my version, it says sheepish.
No,
Did
we're
I say
referring
sheepish?
to the defendant.
Defendant.
Oh.
Yeah.
Sorry, I didn't get that. Can you
You-
repeat the question again?
Yeah, I could, of course. In your report, you described Mr. Savage as being sheepish when he returned to apologise.
No, I didn't say that.
It is there.
Yeah.
Yeah, second paragraph. I was fine, just a bit wet and slightly annoyed, but I have to admit it was quite funny. To his credit, the guy, Timo, came back to me, sheepishly apologised and gave me £20 for the trouble.
Oh,
So it
but-
is there. But
Oh, yeah, apologies.
Yeah,
I
carry
can
on.
see it now. Sorry. Yeah, so he apologized. Yeah.
Okay. You say that you found the prank to be humorous, but did it ever occur to you there could be repercussions?
It could be.
Did it ever occur to you that there could have been repercussions from the prank?
No.
Okay. So, never mind, that's a speculative question, I'll withdraw that. According to my resources, you were present at the smoking shelter at the time of the accident, correct?
With Mrs. Banks?
With
or
Miss
myself?
Banks, you were still present when
Yes,
she...
yes.
Yeah, okay. Can you explain this instance, the event as you remember it?
Okay, so after he left, after my conversation with Mr. Timo, he left, And I was busy with my phone, and I brought out another cigarette because the other one was apparently wet. I lit the cigarette and I was with my phone, obviously not really obvious of what was happening around. And I noticed, all of a sudden, that the lady ran close to the shelter where I was, and she was obviously, shaking and apprehensive. And we all rushed towards her, and some other persons that were close by also rushed towards her. Mr. Timo was there, myself, and then the lady and some other persons. I think she had a friend with her. I can't really recollect now, but we all rushed towards her, and we tried to reach the paramedics to come help her.
Okay, thank you for that recollection. Do you understand why somebody might try to run away from a water gun?
I think the reason might just be the appearance of the gun, because a water gun looks like the real gun. So when you see it, you might not really know that it's without, the bullets. So.
Okay, but if you had the possibility, would you try to avoid getting wet from a water gun? Would you try to avoid it?
For the fun of it, I want to participate. If it's a water gun, why not?
Yeah, but do you understand why somebody may try to run away from it? Why somebody might not want to get wet, so to speak?
Maybe for health reasons. Maybe if they probably have some health conditions that don't allow them to get exposed to cold. Probably they might want to avoid that.
Okay, and
but
are you aware?
It's fun.
Yeah, sorry, my apologies to you. Want to repeat that last part?
But I think it's fun.
It's fun.
Prank, yeah.
Okay, are you aware of the specific injuries that have been inflicted upon the victim as a result of this prank?
Well, I didn't follow up. So when the paramedics came, they picked her up and then they left. So I wouldn't know what injury. But at the time, at the locus, she wasn't visibly injured. She was just shaky.
Okay, so as we now know, Miss Banks suffered a broken nose and a concussion, which lasted 2 months. The effects of this concussion. Would you describe this as being a severe injury?
It's an injury, but I'm not an health personnel to know whether it's severe or not. So I'm afraid I may not be able to comment on that.
Okay. So, in summary, would you say that Mrs. Savage's actions resulted in serious harm?
I think that would still be dependent on what the results or medical investigation shows. It may have contributed, but not necessarily be the only factor that probably led to all of that.
Okay, thank you, Miss Ahab. Sorry, Your Honour. I have no further questions for the witness.
Anything in re-examination?
Permission to re-examine, Your Honour. Based on the conditions on the day, you've mentioned that it was a nice sunny day, wasn't it?
It was.
Yes.
It was. I didn't get that.
A nice sunny day.
Yes, it was.
Yes. So, based on those conditions, would you say members of the public, especially children, may use such water guns and play with each other?
Yeah, I think it was also holiday, so the children were on break.
Okay.
Yeah, so maybe children would have done that too.
Okay, so this is something...
It's not impossible.
My apologies. So this is something which an individual may sort of expect during that time of the year?
Maybe.
Okay. Thank you, Your Honour. That's the end of my examination.
Okay, thank you. Yes, I have nothing further. Thank you very much. You may sit down. Okay then. Yes. Are you ready for your closing statements?
I am, Your Honour. Thank you.
Okay. So yeah, we'll go straight to that, and then I will direct the jury as to how they should find it.
Thank you, Your Honour. Ladies and gentlemen of the jury, in my opening statement, I mentioned that I would call upon the complainant and one witness as to testify to the defendant's guilt. Each witness testified as I explained, and we have established the following facts beyond a reasonable doubt. First, that the defendant did indeed use a water gun to attack Miss Sarah Banks on the date of the 25th of August of the year 2021. Second, that Miss Banks suffered severe harm as a result of these actions and suffered severe injury. And, ladies and gentlemen of the jury, the laws of our great country are clear and certain. As established in the case of the Crown against Lamb in the year 1967, there can be no assault without fear. In application of this case to the one that we are currently discussing in this courtroom, it should be unconditionally clear to everybody that Miss Banks felt fear in this instance. She tried to run away. She wanted to escape it. That, in my eyes, is fear. So in that moment, we can determine that Miss Banks feared for her immediate safety, and by the laws of our common law and our legislation, that is an assault. In addition, in the case of the Crown against Donovan, it was held that the injuries caused by assault occasioning actual bodily harm do not need to be permanent, but merely need to be more than merely transient and trifling. In this instance, I implore you to review the evidence. We know that Miss Banks suffered a broken nose and a concussion, of which the effects lasted for 2 months. Surely, in the eyes of a reasonable individual, this level of harm would constitute a level of harm that is more than merely transient and trifling. Ladies and gentlemen of the jury, I now ask you to turn your attention to Miss Sarah Banks. And consider this. On the day in question, all Miss Banks wanted to do was enjoy a cigarette, as everyone in this court has the right to do so if they wish. Instead of this, she suffered a broken nose and a concussion, which plagued her for 2 months. Instead of the enjoyment which she anticipated, she was made to fear for her immediate safety. I ask all of you this, esteemed members of the jury and the court, to empathise with my client and understand the severity of the defendant's actions. When you take all of this into account, there should not be a conceivable way to argue that it was just a prank, or that there was no malicious intent, or that a water gun is not severe enough to cause serious harm. But I ask you all this now: what sort of precedent would we be setting for the future of the legal system of the United Kingdom if we justified this type of behaviour? Ladies and gentlemen of the jury, we would ask you to reject the defence theories of the case. Our witnesses are credible sources. Their stories are consistent with one another and the evidence that has been provided to the court on this day. On the other hand, the defendant has every means to try to avoid punishment. He does not want to be held accountable for his actions, and he has a serious reputation to uphold due to his presence on social media and YouTube. In conclusion, ladies and gentlemen of the jury, Your Honour, we have established that there is indeed an actus reus through the prank. We have attempted to prove the mens rea through the defendant's reckless behaviour, and we have proved beyond a reasonable doubt that the complainant has suffered severe bodily harm. Those are the 3 principles on which the law of actual bodily harm is established, and in this case, we can show each and every one of them. If I can draw your attention to the offences against the person act upon which this case is built. Section 47 clearly states that whosoever shall be convicted of any assault occasioning bodily harm shall be liable to be kept in penal servitude. Ladies and gentlemen, it is important in this country that people in a society need to be held accountable for their actions. Ladies and gentlemen, you have heard from our witnesses. All we can do now is await your verdict. I implore you to review the evidence and arrive at the correct result, that this defendant should be seen as guilty. Thank you, Your Honour.
Thank you very much. Mr. Okay.
Your Honour and members of the jury, on behalf of the defendant Mr. Timo Savage, I would like to make the following submissions. There is no dispute within actus reus for the predicament and the severity of the injuries sustained by the complainant Miss Sarah Banks. However, the defence today challenges the evidence in relation to mens rea, contrary to Section 47 of the Offences Against the Person Act 1861. Additionally, the element of causation will be explained and will be differentiated with the omission of the defendant. As pointed out by my learned colleague, the mens rea of a Section 47 assault contains 2 categories, namely intentional conduct and reckless conduct. The first issue here is whether Mr. Savage intentionally harmed the complainant in question. There are witness statements from both the defence and the prosecution which oppose this notion. For example, in the testimony of the bus driver Christian Hobbs, who is the most neutral witness within this trial, he points out a level of ambiguity surrounding a prosecution for the intention of the defendant. As asserted under oath, Mr. Hobbs stated he was fine after being part of a prank prior to the incident, which was with the complainant, and admits that the prank was quite funny and was compensated for the inconvenience that Timo had caused. This therefore rules out any intentional motive to cause harm to an individual and provide some form of content after the prank was made. I respectfully submit to the court that Timo did not literally mean to be or physically assault Miss Banks. As a self-employed filmmaker, it can only be considered that he was trying to be innovative in the way that he was publishing his content, and moreover possibly gain a satisfactory income, as he has stated within his witness statement. from the idea of the smoking gun. Prior to the court hearing, Timo had stated that there was no issues or altercations with any individual prior to this. And reading through his comments in isolation, it would not prove criminal intention beyond a reasonable doubt, in my respectful submission. With regards to causation, it must be first proved that the defendant's conduct was the factual cause of the injury sustained by the complainant. This may be referred to as sine qua non, and the case of R.V. White, 1910, is a significant case which outlines intention and whether a factual cause can determine a conviction. In relation to R.V. White, the defendant, Mr. Savage, did not intend to harm the complainant as expressed within his witness statement to the police, but furthermore, the factual cause of the injuries and the concussion was through impact of hitting a pole from fleeing. As it has been established by the complainant, she does suffer from severe panic attacks, which is triggered from the sight of liquids being sprayed, and from an incident which had occurred prior to one which was present in court today. As the liquid did not touch either Miss Banks or Mr. Hussain at the time, it cannot be considered that a factual cause with reference to actus reus. And additionally, the Mental Health Act 1983 states that a mental illness, trauma, within this case it is, or impairment by the Mental Health Act are inclusive of emotional and volitional impulses, and may constitute towards different urges or impulses by an individual. As stated previously, the trauma experienced by the complainant did contribute towards a psychological decision to flee upon seeing the sprayed water, thus resulting in the injuries being sustained by the complainant. This therefore provides in the break of causation, and additionally, the case of R.V. Williams and Davies, 1992, can be referred to here, with regards to the novus actus interveniens of a case. As respectfully mentioned previously, Timo's actions were not reckless, and the reaction from the complainant was not foreseeable at the time. It may also be speculated as to whether an individual provides honourable consent within such cases. For example, is there a reasonable expectation that in a public place on a beautiful sunny day, individuals may play with such children's toys, and also during that time of the year as well? As respectfully submitted earlier, the defendant did not deliberately assault the complainant. Therefore, it can be strongly argued that consent may also be used as a defence to also prevent Mr. Savage being convicted of a Section 47 offence against the person. I respectfully submit to the court that the defendant, Mr. Timo Savage, should not be criminalised for the assault occasioning bodily harm, even if the conduct can be deemed reckless within its nature. To conclude on my summary, I would finally like to point out the members of the jury should pay due regard to all the circumstances pertaining to the incident, as will be explained by His Honour. For example, an incident such as this has never occurred before, and that the foreseeability of sustaining such injuries were not apparent at the time. Additionally, the jury may wish to consider the context upon which the assault had occurred. For example, the psychological well-being of the complainant and the panic attacks in which they experienced, as this did contribute towards the complainant fleeing. A comparison to this may also be that her colleague was standing still and only dodged, outlining different impulses and behaviours between the two. These are very important circumstances to consider before reaching a final verdict, and with that, Your Honour, that is the end of my submission.
Thank you very much.
Thank you.
So, the matter now turns to our jury to make the determinations of fact with regards to what we have heard today. Just in summary, I know we've been through it quite a bit, but the case against the defendant, Mr. Timo Savage, is that he went into town to make a YouTube video, sprayed people in the face with water or close to them with water. This then caused somebody to panic and run in fear and hit her face into the side of the smoking shelter. Now, on the basis of this, the prosecution has brought a charge under Section 47 of the Offence Against the Person Act of 1861 that commonly is known as ABH, or actual bodily harm, or assault occasioning actual bodily harm. On the basis of this, there are a few things that the jury has to determine. Right? Firstly, that the assault indeed has happened and that it has created the harm. We have heard in our closing statements there words to that effect, and you have to make your determination on that. In that, we can see, right, the issue of causation arising, right, that the assault has caused or occasioned the harm to that victim. On the basis of this, there is the test of novus actus interveniens, or a new intervening act which may break the chain of causation between the original act and the eventual injury that has resulted to that victim, Miss Sarah Banks. In this situation, it is therefore up to the jury, as you have heard from the closing statement from our defence here, that there may well be a new intervening act. That is for the jury to make that determination as to whether or not you are satisfied that there has been an intervening act which may break the chain of that causation. Okay, in doing that, right, you have to have regard to whether or not the victim's acts are predictable, right, and foreseeable. Right, we have heard lots of evidence, or lots of questions, indeed, in fact, which lead to that, which pertain to that issue of whether or not the running into the side of the smoking shelter should be seen as predictable or indeed foreseeable in that situation. It is up to the jury to make that determination as to whether or not Miss Sarah Banks' response was foreseeable and predictable. Further, we also heard reference to what we call in the criminal law mens rea, right, the mental element of a criminal offence, which in this situation, for an offence of Section 47, Offence Against the Person Act of 1861, could be intention or recklessness. Now, we heard in our closing statement from the defence that, we heard quite a bit about intention, or trying to deny the fact that there was any intention. I don't think we heard that from the prosecution that they suggested intention. All I heard from the closing statement from the prosecution was that you're relying on recklessness, and recklessness being the relevant mens rea in this situation. So I think I can direct the jury to ignore intention, that Mr. Timo Savage did not intend the injuries to Sarah, that his intention was to make the YouTube video, and what happened was a happenstance. Now, the determination for the jury is as to whether or not that happenstance is reckless, right? Whether he should have foreseen the risk of the injury to the victim and went ahead with his actions anyway in that situation. So, on that, it is over to the jury to make that determination. Thank you very much. We shall adjourn and return for verdict. Thank you very much.